కుదరా
I respectfully welcome President of the Bar Association, I heartfully welcome the Guru Prasad garu, the military advocate of our Bar Association and the speaker of the day. Guru Prasad garu. Let's start the program with the Vande Mataram. Sujalam Supalam Malayasitalam Sasyamalam Mataram Vande Mataram Subrajosna Purakidayamini Mullakusumita Sumadana Shobhini Suhasini Sumadura Bhashini Sukhalam Bharatam Mataram Vande Mataram Vande Mataram. అందరికీ నమస్కరిస్తూ లా స్టూడెంట్స్ అందరికీ కూడా న్యాయాధికార సంస్థల చైర్మన్గా ఆశీర్వాదం అందజేస్తున్నాం. ఫ్రెండ్స్, all of you are well aware the object of the convening this meeting today, as per the direction of the Honorable Supreme Court of India and of the guidance of the Honorable High Court of the Andhra Pradesh of Judicature. Today we are conducting a meeting not to discuss the pros and cons of the kesavananda case. Why we are discussing about the kesavananda case? What is the reason behind it? Because the kesavananda judgment age is 50 years. The age of the kesavananda is 50 years because it was pronounced on 24/4/1973. 24/4/1973 kesavananda Bharati కేసులో జడ్జిమెంట్ చెప్పబడింది. సో నేను జస్ట్ కింగ్స్ అండ్ అవుట్స్ మాత్రమే చెప్తాను. మిగిలిన వాళ్ళు చాలా మంది స్పీకర్స్ ఉన్నారు. మోర్ పర్టికులర్గా మేమంతా కూడా జడ్జెస్ అందరూ కూడా వీ వాంట్ టు హియర్ ది వాయిస్ ఆఫ్ ది స్టూడెంట్స్ యొక్క వాయిస్ వినాలనుకుంటున్నాం. మీలో ఎంతమంది మాట్లాడితే అంతమంది మేము హ్యాపీ ఫీల్ అవుతాం. స్టూడెంట్స్ అందరూ కూడా బయటకు వచ్చి మాట్లాడాలి. దిస్ ఈస్ ది రైట్ పార్ట్ ఆఫ్ దిస్ ఈస్ ది అకేషన్. వన్ హ్యాస్ టు రైజ్ ది అకేషన్. కాబట్టి మీరందరూ కూడా ముందుకు వచ్చి గుడ్ లీడర్ యొక్క క్వాలిటీస్ ఏంటంటే రైట్ ఆర్ రాంగ్ మాట్లాడండి. మేము జడ్జెస్ ఎప్పుడు కూడా మంచి వక్తలై ఉండకూడదు, మంచి శ్రోతలై ఉండాలి. మంచి వక్త అయినాడంటే కింద ఉన్నటువంటి అడ్వకేట్స్ ఎప్పుడు కూడా బాధపడుతూ ఉంటారు. మేమే మాట్లాడుతూ ఉంటే అవతల వాళ్ళకి మాట్లాడే అవకాశం ఉంది కదా. మరి ఇప్పుడు అడ్వకేట్ అన్నాక వాళ్ళు ఎక్కువ మాట్లాడాలనుకుంటారు. బికాస్ దే వాంట్ టు సబ్మిట్ ద కేస్ బిఫోర్ ది బెంచ్. కాబట్టి ఎప్పుడు కూడా న్యాయాధికారి మంచి వక్త అయి ఉండకూడదు, మంచి శ్రోత అయి ఉండాలి. అట్ ది సేమ్ టైం న్యాయవాది మంచి శ్రోత అయి ఉండకూడదు, మంచి వక్త అయి ఉండాలి. మంచి శ్రోత అయి ఉన్నాడంటే ఆయన ఎంతగా నేర్చుకుంటాడు. వినడం కాదు వాళ్ళకి కావాల్సింది, వాళ్ళ వక్త అయి ఉండాలి. కాబట్టి మీరందరూ కాబోయే ఫస్ట్ న్యాయవాదులు, తర్వాత మీరందరూ కూడా ఈ యొక్క ఆడవస్తున్నటువంటి న్యాయమూర్తులుగా కూడా కనబడతాం.
Power to amend the constitution is not power to applicate the constitution. So they can still amend the constitution, but it should not change the basic structure. So here comes the doctrine of basic structure. The Supreme Court and High Court did not explain like what is the basic structure or doctrine of basic structure. But it had been saying from case to case, like from Sajjan Singh, Shankari Prasad, Golaknath case, Kesavananda Bharati case, Ambika Mir case. All of this, it had been saying that these are the features which are included in this basic structure, like supremacy of judicial review, independence of judiciary, and secularism, sovereignty, and harmonious relationship between fundamental rights and the cases, that is, principles of of state policy. This had been the future to the basic structure doctrine. And even now, there had been telling what are the features which are to be included in the basic structure. So, the difference which had been taken, like Shankari Prasad case and Sachin Singh case, says that Sachin Singh is a Zamindar who, after the amendment of First Amendment Act 1959, Shankari Prasad Sachin Singh, the Zamindar, he took Article 30. While he went to the court and said that they referred this Article 30 and to this. And court had said that you're saying, whatever you're saying regarding Article 13 is correct. That is Article 13A, Article 13B, which says about pre-constitutional laws and post-constitutional laws. They are correct. But even Article 30, subclause 3 says that whatever includes in the law, what are the things that are included in the law. And court says that there are two provisions for the parliament. That is to make ordinary law and that is to make constitutional law. Whatever the process used regarding this ordinary law would become law. And if they use the process of constitutional amendment, then the law would become constitutional law. So there would be no value for the court to enter in those constitutional laws. So he lost the case there. But in Golagha judgment, it had said that even it's an landmark judgment. It had said that court can review or review even this constitutional law. Because whatever in the name of this, Vajraid or there, using this article 368, they can't amend everything. Because if they amend everything and if they give us the supreme power, then in the name of socio-economic obligations, in the name of people, in the name of public, in the name of people.
The students of law, both the State University and General Law College, I confess that I may not be in a position to repose the trust placed by the Honorable District Judge after hearing Mahita for the reason of 50 to 40 years back, when we were students like this, we heard about kesavananda Bharati, and after we entered into the profession, there was absolutely no opportunity to study constitutional provision and read the constitution in its perspective. I place my appreciation on the Dr. Mahati, who dealt the kesavananda Bharati case in a character perspective. And I all invite you to this esteemed legal profession, emulate from Mahiti, and read the Mahima and read the constitution in its correct. 50 long years have been remembered. 70 to 73 years of unclear constitutional history. Why kesavananda Bharati is English? Why kesavananda Bharati case is two contentions, as the speaker said, it runs about 700 pages. The excellence of the Supreme Court, 13 judges bench, for hearing that matter for about 68 days, by the legal luminaries on that day, and even now there are legal luminaries, and you all know, she was the written constitutional book, which is an authority on the constitution, and Nani Bharatiwala on one side, eminent attorneys, solicitor generals, argued this matter for 68 days, and the court patient enough. On all working days for about 2 months and 8 days, you can imagine the patience of that constitutional bench. So 50 years have been rolled out in the democratic party. What is the relevancy of the constitution, this ruling, even after 75 years of Indian independence? What does the contentions that were raised in that particular case? So there are many submissions, as many as 71, the provisions of 71 nations constitution was considered, more than 100 rulings were cited, and the Supreme Court divided, say 7 judges majority and 6 judges divided on this aspect. So the principal question that was addressed in that case is that whether the supremacy of the parliament vis-a-vis the charter of the Supreme Court or constitutional court. So it canvassed the great legal luminary of the day, most learned Syria, Silva, argued that the parliament is supreme. The parliament has got unlimited power to amend the constitution in pursuit of its socio-legal economic obligations conferred on the executive under the preamble of the constitution. So it was argued the state is no more a defense to prevent external aggression and protect its citizens, and to maintain law and order, internal law and order. The concept of the state has been changed. The concept of the state from its traditional duties has been evolved as welfare state. So when once the state is evolving as a welfare state, the parliament should have unlimited and unfettered powers to amend the constitution in tune with the social and the economic relations happening under the country. So there, it was argued that the members of the parliament or state legislatures were elected by democratic republic policy. You must find the distinction between democratic and republic used in the constitution. By majority franchise, and that wisdom, with that wisdom, the parliamentarian are entitled to pass resolution, and the executive cabinet is answerable to the legislature and the parliament. In that way, it was canvassed that the power of parliament cannot be curtailed to amend the provisions of the constitution if the exigencies. That was the main thrust of the argument that is canvassed in support of the power of the parliament. And they said that the judicial review by two individuals sitting in the air-conditioned chairs, air-conditioned halls, is not a substitute to the wisdom of the parliament which is elected by the sovereigns of this country, that is the public of that country. So then the other side argument was, the parliament shall not be conferred with unprecedented power and unlimited power. There is every likelihood of misuse and abuse of such a power, even to defeat the constitution and to change the nature of the constitution, and that there will be anarchy in the Indian society, the counter argument that is canvassed by Nani. So now, why this ruling is relevant? This ruling is past 40 years has rolled out. We are seeing the work of legislature, we are seeing the work in the parliament. I did not find any illustrative, any argument either by the party in power or the opposition parties. There was absolutely no valuable and significant discussion with respect to the law that has been enacted by the party in power. So it is nothing but lucas, nothing but big-writing. Even big-writing we are seeing in legislatures and parliament, and many of the parliamentarians doesn't know even the preamble of the constitution. Forgive me for saying so. So in the context of that parliament, there is absolutely no intellectual, barring a very few. It's only a mockery. If for the executive puts a bill in either of the both the houses, they will just lift a veto will be issued to them, and they will lift their hands even without knowing the contents of that legislation. So that is the scenario which we are facing. That is the attitude of the parliamentarians and legislators. And if the sacred democratic republic is placed in their hands to upgrade the curtail the fundamental rights, what should have been the fate of the citizens of this country in the absence of Kesavananda Bharati, in the absence of Sajjan Singh versus Women of India, where his Lordship Justice Malhotra supported the theory of basic structure in interpretation while working whether any legislation is passed by Parliament or by state legislation is ultra virus of the Constitution. So the Constitution is a gun now. It is unbreakable. Every legislation that is passed either by the Parliament or by the legislature must pass through the test of the provisions of the Constitution. So there, the judiciary resolved its power based on the doctrine of separation of power as some of the friends said under Article 50. It resolved its power to judicial review, and in fact in lower class, as somebody said, the judges are reluctant to give arbitrary power to the Parliament to amend any of the provisions of the Constitution. So in the background of the ruling of lower class, and as Mahima has said, right from Sankara Prasad up to Jabalpur, GM Jabalpur versus this which is called as habeas corpus case, all these cases uphold the power of the Parliament to amend the principles of Constitution, and a stumbling block has come by Golakar to the extent that the Parliament has no unbridled, unqualified powers to amend the provisions of the Constitution. This made the Parliament agreed by that particular decision. They have introduced 24th, 25th, 26th and 29th Amendment, and in particular, their lordships in the ruling interpreted Section 3, Article 386 of the Constitution only. It lays down the procedure for amending the Constitution, and no power is conferred under 386 to enable the Parliament to amend the Constitution. That implement and that interpretation was sought for. So please imagine, in the working of the Parliament, with great respect to the parliamentarians or legislators, as to how it has worked for these 3 years, so reposing trust on the electorate that their wisdom, and we are seeing nowadays the welfare means giving free beds to the electorates and secure votes and rule the country. So the concept of welfare is misunderstood and misconstrued by both the parliamentarians and also by the legislators, and all they say that it would be a national party or it is a regional political parties. So then, if in the absence of Kesavananda, in the absence of the wisdom of the enlightened judges of this great country and the learned advocates for their hard work, perseverance and eminence to read months together of 71 nations to Constitution and the ratio of hundreds of binding precedents of not only our country but US, England, Australia, Japan, whatever it may be, again other 50 countries, and considering the socio-economic conditions of this country. Very, very significant is the socio-economic conditions of this country. This is a great constitution where under its wings, people of different diversities, people of different cultures, people of different religions, people of different economic standards, people suffering with illiteracy. So by the time, nearly 60% of the Indian population was illiterate. So the illiterate, ignorance, who doesn't know the value of the democracy, and if that constitutes the electorate of this particular country, if unbridled power would have given to the parliament or state legislature, they would have repealed the constitution. They have converted this parliamentary federal structure of the constitution into a different category presidential rule they would have imposed. We have seen the sufferings of these people when late Indira Gandhi, Madam Indira Gandhi clamped emergency and thereby suspending partly of the Indian Constitution. So scores of persons for no reason were taken to custody, put in jails, and much together all the intellectuals of this country were languished in jails. So in that context, the Supreme Court is called upon to consider whether the 24th, 25th, 26th and 29th Amendment Act, and this court has got opportunity in kesavananda Bharati case. So these were not the subject matter of that particular case. Assigning 24th, 25th, 26th and 29th Amendment to Constitution. In them, in Sankari Prasad, the court uphold the power of the Parliament to constitute, to amend the Constitution and uphold the 20 amendments which are made to the Constitution. Can you visualize? American Constitution is about more than 300 years old. There are only 27 amendments so far. In the 70 years of the Indian constitutional history, so far 150 amendments are made to the Indian Constitution. So there, the court has to consider. So after question when in Goraknath the court said Article 386 confers it's only a procedure for amendment of the Constitution, and it does not include the power of the Parliament to amend the Constitution, and as you all know, 386(4) has been introduced in the 24th Amendment, and thereby the court wants to have exercised unlimited power to amend the Constitution. So then, after hearing all these questions, and another important aspect, so we were also apprised when this law has come, being influenced by the haves and have-nots of this country, where the court in the 25th Amendment said, the court has got an absolute, the Parliament, the executive has got absolute power to requisition and to acquire lands and pay amount. So what is amount is not defined. It may be to that and that the other clause that has been made, this amount that has been to that person is not justiciable in a court of law. The power of the court to determine the quantum of the amount that has been paid to the government to approach the apex court or constitutional court has been taken away by this amendment. So visualize in the political scenario. If the word amount is not interpreted in kesavananda Bharati to that extent, and the amendment clause 2, which takes away the right of the citizens of this particular country to approach constitutional courts for inadequacy of compensation, or compensation is not determined in accordance without any rational. So, the present government, if that amount was allowed to be so, we are seeing likes and dislikes in the government. They may pay 1 lakh to a land to the person who allegiance to his party, and even a 1 rupee to the person who is having allegiance to the opposite party. There was so much of space for discrimination between the citizens of this country, and that has been sought to be averted. These are the two essential importance of this case. So the court said the reasonableness has been introduced. Even if you say that it is an amount, it is a compensation which is to be paid at least equivalent to the market value, present legal market value when the property is acquired. So these are the two important observations, important ratios that impacted the nation's growth, that impacted discrimination between the citizens. Even after 50 years, when we see the working of the Parliament and legislature, we have to stood up and say homage to their lordship, who had a vision of, we had a vision of the destiny of this particular nation. If to see that the republic structure of this constitution and the primacy of Part 3 of the Indian Constitution shall be preserved, otherwise there will be anarchy. The executive by utilizing the powers of amendment in this, they may repeal or abrogate many of the provisions of the Constitution. That is how this in deviance to Golaknath, Kesavananda Bharati has given limited power to this Parliament to amend the provisions of the Constitution. So it's not a case where the power of the Parliament to amend the Constitution is completely taken away in Kesavananda Bharati. So it said it has imposed limitations. It reserved its right to judicial review. So the emphasis in Kesavananda Bharati cases, the Supreme Court reserved its right for review of the legislature to find out whether it is intra-virus of the Constitution or ultra-virus of the Constitution. So this is very much important for a student of law. So the unfettered power of amending the Constitution and taking away the rights of the people which are conferred by Part 3 of the Constitution and to make laws according to their own will choice has been jettisoned by the decision of the Kesavananda Bharati case. So there they said. So we have also, you must know, you are because of your final student, perhaps in the secondary itself you read the Constitution. Section 13, as Mahima said, all the laws, post-dated laws. So even by the time when the Constitution came into force, there were a number of statutes which govern the polity of this country, and all those laws that we will not all post to us before the Constitution came into power, laws inconsistent and in derogation of the fundamental rights or abridging fundamental rights, to that extent all the said laws are repealed. And such of those laws which stand the test of the provisions of the Constitution, such laws that were enacted even prior to the Constitution coming into force has been retained. Rights. So what the clause 2 says, rights confined by this part, by part 3, by this part means part 3, made in contravention of part 3 of the Constitution, the court said the provision reads as void. So in order to get over, so when in Golaknath they said 386 is only a procedure, it doesn't confer any power to amend the Constitution in the Parliament, and in view of the fact that 13.2 is that any provision that is made in contravention of the fundamental rights guaranteed to the citizens of this country under Part 3 of the Constitution as void. So they have amended, introduced clause 4 to section 386, where they said all the laws that are made under the 386 are not amenable to the jurisdiction of the Supreme Court or other constitutional court, and it has no, it will not affect the, notwithstanding the section article 13 of the Constitution, the amendment made is sought for. So then, what are the basic structures? The court has, it's not in Kesavananda Bharati, the theory of basic structure is a word. Section 6 itself is Lordship Arvotra, evolved the theory of this basic structure. So the Supreme Court, even in Kesavananda Bharati, has not defined what is the basic structure of the Constitution. So the great thing that their Lordships, even the Lordships who decided this particular case, they said that what is the basic structure they have left out loose power to the judiciary, that it is left out to the court while considering a particular legislation whether it offends the basic structure of the Constitution, and they have only narrated few, as somebody said, the supremacy of the Constitution, democratic and republican quality of this particular country, secular and federal structure of this country, and so many things. It is only illustrative. They have said 6 or 7 items which are illustrative are not over. So by virtue of this ruling, where the Supreme reserved its right to review. And the courts went to the extent of both the judiciary and the parliament, the powers of judiciary and the parliament are coextensive with each other, and each are supplementary and complementary. And so, in spite of the large wisdom of this particular electorate of this country and the wisdom of the parliament, the intelligentsia of the judges of the Supreme Court, the intellectual assessment, consideration of the things that are happening in the given society, the Supreme Court, by virtue of judicial activism, even when there is void with respect to some provision, the Supreme Court needs to give direction, which is a law under Article 146 of the Indian Constitution. So this is the essence of Balaji case, and for paucity of the time, as you know, 700 pages, so many contentions, and so many books referred, and so many constitutions were referred. It is not sufficient even to 1 year work, at least 10 days. If you are patient enough to do, you can examine all the aspects of Kesavananda Bharati, and I am very glad, really I am impressed by the students of State University and also the students of Krishna University for their eminence. When we were students, except knowing Kesavananda Bharati, we do not know what the document, what the doctrine of exilip is. So because as the Honorable District Judge said, we are also students, backbench students, not front side students. So these are there are 10 very important, which has brought so much relevance to the life and livelihood of the poor peasants or poor poverty-stricken masses of this particular country. And we were also grieved. I am telling you, I will finish with one word. So when the court said that when in the 25th Amendment, by reserving the power of acquisition, by removing the power of taking over, they have mentioned amount, and a prerogative right is conferred to the executive to fix the quantum, and that quantum that has been paid for acquisition land, the Act says it is not destitute. So, as we thought as a progressive, there was so much of criticism with respect to the interpretation of the amount in the Kesavananda Bharati, which they said it is compensation payable equivalent to the value of the nation. Visualizing 70s, the country, the nature of this country. All the land. So land is so much important to the extent the power of the government to take acquisition of the land of Kesavananda Bharati, the court has not given him relief. So it is said if you want to acquire that land, pay compensation. The whole check of the land in this country was only in a few hands. There is Jamindari Vyavastha, there is Inam Vyavastha, there is the estate Vyavastha, there is all the Rajas were holding thousands of acres of land in this country. In fact, the Supreme Court in its earliest judgment, it was status quo oriented, it was not progressive. So right from Kesavananda Bharati, and thanks that Justice Chinnapalli, Justice Desha, Justice Bhagavati, all these progressive judges has gone to the Supreme Court and renowned Krishna here, renowned Koka Subbarao, who hails from our state. These are all the progressive judges. So we were agreed. So if the state has to pay, if to acquire all these land and distribute it to the peasant, if the state has to pay compensation equivalent to that, how is it that Jamindari Vyavastha is abolished in this country? Apart from the land, they are getting the money. Tons of money has been gone to the markets of while because of the rulings of the Supreme Court. Earlier to Kesavananda Bharati, in the case of privy purses, in the case of Jamindari abolition, all these things. So we were agreed by this decision. While implementing, but you see the scenario, this judgment has become so relevant because of the accentuation of the political rivalry and lack of will on the part of the legislators and parliamentarians to do the best to the citizens of this country. Believe me, even after 75 years of Indian independence, that is 30% of the population which is striving to earn well-paid people there. and crores of property. We are putting great extent this Reliance properties.
అనేది ఫైనల్ కన్క్లూజన్కి వచ్చింది. ఫైనల్ కన్క్లూజన్ ఏంటంటే మన యొక్క రైట్స్ని, పీపుల్స్ యొక్క రైట్స్ని ఎఫెక్ట్ చేయకూడదు. ఇదివరకు ఏంటంటే వితౌట్ కాంపన్సేషన్ ఎంక్వైరీ, నేను ఎంక్వైరీ చేశాను, నీ మీద కోపం వేరే పార్టీ, నువ్వు ఫలానా పార్టీ, నేను వేరే పార్టీ, నేను ఇప్పుడు అధికారంలో ఉన్నా, నీ దగ్గర ఉన్న అంతా తీసేసి ఇది ఇల్లీగల్ కదా. దాన్ని గుర్తించింది సుప్రీంకోర్టు, దాన్ని గుర్తించింది. అలా అంటే ప్రతి